that y'all are able to come in. I have a really great guest today, somebody that has spent his adult life in the insurance industry, like the way a number of us have, and somebody that I've learned from far away. And I'm really pleased that Chris Boggs is come to join us, tonight. Chris, thank you very much for being on Claim Game tonight with us.
I appreciate you having me.
I just so everybody gets to know a little bit about you, and I know people have, I believe that so many of us that have learned so much from you over the years, but we really don't know, who you are, where you came from. And I always ask this question for people, like, how in the world did you ever first get started in this insurance field? What interested you in it? What brought you to it? Can you just tell us from the very beginning where this all came from?
Nothing interested me about the insurance business. That was not the intent. My degree is actually journalism with a concentration in advertising. I had intended to be an advertising copywriter. And when I got out of college, there were no jobs. Not unlike anybody else just getting out of college, but my dad worked for ISO. And they were starting a new position. They had just started doing loss control surveys and things like that, and which required a description of operations, and it went into far more detail about the business rather than just rating. And what they discovered was that the field reps weren't necessarily good writers, so they were hiring me to be to take what the field reps had written and rewrite it. And they said, but if you're going to do that, you need to go out in the field and learn what they do. Well, the position they had hired me to do never actually materialized. So the first 4 years of my insurance career with ISO was as a field rep, inspecting and rating and writing about description of operations of buildings. And I thought, since I am in the insurance business and my degree is in journalism, I might want to study insurance. So 2 or 3 months into my career, I began studying insurance, doing the INS designation, or now the AINS designation, and began learning about insurance, and discovered that I actually enjoyed it. I'm a sick person is the only conclusion that I can draw, is that I actually enjoy insurance. I enjoy policy language. I enjoy talking about insurance. My wife likes to tell people that I salivate over insurance. She's glad I enjoy insurance. She could care less about it, but that's fine. I can deal with that. And so from there, I left ISO and went to the agency side of the world and was an agent for a few years, and also worked for the Department of Insurance along the way, and then discovered that I enjoyed, again, talking about and teaching insurance. So most of my career has revolved around teaching and education and training as it relates to insurance, starting way back with the independent insurance agents of North Carolina, and then ultimately with the National Association a couple of years ago, where I left there to go to work for ISO. Again, I actually started ISO almost 29 years to the day that I left ISO. So there's a 29-year break in my employment at ISO, and I went back to ISO to run the commercial property team. And that's a whole different story. If you want to talk about it, I'm happy to talk about it, but that's a whole different story, which led me to start Boggs Risk and Insurance Consulting, which is where I have been for about 16 months or so now. So that's the brief description of how I got in the insurance business. It was not intended by any stretch of the imagination.
Well, for everybody who's watching this evening, Chris, thank you very much for that background and explaining, how you got to where you are, today. And for everybody else that's watching, you can write questions down in the chat. I have Kathy McConnell who will come back and help read some of those if I'm not able to. And Chris will have those questions as we go through. And Kathy, you can stop us, although I plan to spend it as we get close to the end to have a lot of those questions in there. But I guess I want to follow up with this. There's a number of people who might not understand the ISO and just a brief history of the ISO and what the ISO plays today, and insurance. And maybe you can just go over that with everybody. So just to make sure everybody's on the same page with that.
Okay. I sort of do a brief overview of the history. Actually, when I went to work for ISO back in 1990, they were owned by the industry. They were not a for-profit entity. And I've always sort of joked they were a not-for-profit entity because they were owned by the industry. So we had no money to do anything. Then they went public a few years ago. So we were beholden to the investors and the stockholders, so we didn't have any money to do anything. So it's just kind of interesting that even though you changed ownership structure, it was a very different world. ISO in its founding was actually the mixture of several different rate bureaus, where ISO's sort of biggest play beyond policy wording, beyond policy language, is their actuarial background, their actuarial gathering of all the data to help the insurance industry come up with pricing as it relates to coverages and endorsements and things like that. So that's sort of their big play, is the endorsement, or excuse me, the actuarial side of the business. But obviously, as most people know who have dealt with insurance for a while, is ISO is sort of, I hate to use the word standard, but they are this standard policy language provider. They are the largest by far, the gorilla, 800-pound gorilla in the room of developing policy language. And even a lot of the proprietary forms use ISO policy language. So they are the big dog in the fight when it comes to policy language. So whenever I teach policy, I generally teach it from the ISO perspective and the ISO policy language, because they're the dog. They're the ones who get to play in all this. Again, even with proprietary language, ISO is still part of it generally. So that's sort of where they're playing today, and that's where they've played since 1971 when they were first founded. And I always kind of found it interesting. I know this is irrelevant. I always found it kind of interesting that ISO and Walt Disney World opened up the same year. So I don't know if that has a correlation to anything, but it might. There's a lot of clowning. But I'm sorry, didn't mean to go down that path.
No, that's all right. I might use that someday. That's a great line. What was your last position with the ISO that you had just before you left, and what did you do?
Right before I left, I was the commercial property team leader. I managed the team that wrote the commercial property language and getting ready for the upcoming filing that should occur in the next couple of years or so, revamping the commercial property language. And so I managed the team and making recommendations on new policy language, meeting with the insurance carriers who are members of ISO, and discussing potential policy wording changes and endorsement additions or changes or deletions of endorsements. So that was what I had to do. And I took that role because I'm a geek, because I enjoy policy language. So that was the reason why that role appealed to me in the beginning. And you and I were talking before the session began. It's kind of interesting when you get to ISO, what you are allowed and aren't allowed to do and say. And if you allow me just a second, I'm going to run down that path very quickly on a very high level. The thing that my background, as I said, most of my career has been teaching and education, answering coverage questions, answering claims problems, and things such as that. And when I went to work for ISO, I wasn't allowed to do that to the same extent, to the same level any longer. From ISO's perspective, I sort of understand that, because they don't want to paint any carrier into a corner as it relates to policy language, because the carriers are allowed to interpret policy language as they so desire, provided it's a reasonable interpretation of the policy language. So they don't want ISO, even though we wrote the forms, they really don't want ISO representatives, if you will, to say this is what this means, because the carrier might have a different interpretation, or they might have proprietary language, or whatever the situation might be. So I understood the reason why I couldn't answer those questions specifically, but for somebody from the background of teaching and training, it was very frustrating to not be able to, when I got a question from a carrier, when I got a question from an agent, to not be able to answer the question using the policy language. And the very first question that I got involved in, I'd been there about a week, and I got a question, and I answered the question. And using policy language and explaining how it would apply in a certain claim situation, and I had to send things to the attorney to approve answers. And the attorney said, "You can't write that." I said, "Am I wrong?" She said, "I didn't say you were wrong. You just can't give that kind of detail towards the policy language because of, like I just said, they don't want ISO to paint a carrier into a corner at all." And from ISO's perspective, I completely understand it. It was frustrating to me, but I completely understood the reason behind it. And I know it's frustrating to the industry as well that you wrote this language, you can't tell me what it means. No, we couldn't, because of, again, company A and company B might apply the language differently, and also state laws differ and could change how the policy language gets applied. So I understood it. Frustrating to me, but I smiled, nodded, and left.
And then you left.
Exactly. I smiled,
Yeah.
nodded, and left and started my own consulting operations, going back to teaching.
So Chris, what do you do now at Boggs Risk and Insurance Consulting?
I spend my days dealing with mostly with agents and problem claims. I like to get involved from an expert opinion perspective, from an expert witness perspective, with claims that have been what I consider improperly denied. And as you know, being an attorney, there's a lot of improper denials. There are a lot of proper denials. I don't want to overshadow that fact, but there's a lot of denials that are appropriate, and I have to tell the agent, hey, unfortunately, they're correct about this denial, and there's no way I can argue with this in a reasonable argument. I can make one up, but it's not reasonable. So I'm not going to spend the time doing it. So I deal a lot with that, some expert witness work. I work a lot on the education and consulting side. A lot of agencies hire me to do internal education. I have a couple of associations and a couple of other organizations that I do education with or for, writing the education for them or presenting whatever they're asking me to do. So I spend a good amount of time on the education side as well, consulting. And my wife thinks I'm on permanent vacation, so we are at Disney quite a bit. So that's the reason I brought up the Disney thing.
If because you have worked as an insurance agent and now you're educating insurance agents, if I was an insurance agent and I wanted to learn the product that I'm about to sell,
Mm-hmm.
what would be your first priority you would tell me I should go do as a burgeoning insurance agent to understand the product that I sell? What would you suggest?
As sort of what I did is start going to classes. You can read the policy language, you can read it yourself, but there's some parts of it that's confusing. Start taking classes immediately. You've got to get into understanding terminology. One of the things, and I hate to be completely self-serving and say buy my books, but buy my books. I'm sorry, I had to do it.
What's the first book everybody should buy then, Chris? What would you recommend? If I was starting from scratch, I wanted to understand this particular field, the product that I'm selling or the product that I might be involved in claims with, and I want to understand how insurance works. What's that book?
Well, my favorite book in that regards of how this all fits together is called Insurance Risk and Risk Management. And for those of you looking for it, it's on the Insurance Journal website. I previously worked at Insurance Journal as well, but it's at the Insurance Journal website, and it's written as a textbook. It talks about what risk is, what risk management is, and how insurance fits into the whole aspect of insurance and risk management. So that's my favorite book, and that's a good place to start. A lot of the educational providers, the institutes of the world with the CPCU and the AINS, now the AINS and ARM, that is a wonderful place to get started in just learning the basic aspects of insurance, concepts, terms. I do have a series that I'm re-recording here pretty soon on I call it Basics and Beyond. It's the basics of insurance. And basically the way I describe it, forgive the use of the multiple terms of basic, essentially Basics and Beyond takes what you would accidentally learn in the 2 to 5 years in the business and puts it in a 24-hour training session. So it's 8 classes, 24 hours, but training is necessary. This industry, Chip, you and I have had this conversation. This industry has gone off the rails in regards to training, not in a good way. They have gone off the rails because the focus on training isn't what it used to be. And I hate to say the good old days.
Why is that?
My honest opinion of that is MBAs. I'm sorry if you're an MBA, don't get mad at me, but it became about the cost of training, the expense of training, the time involved in training. There was one of my old bosses. He was an underwriter, and before he opened up his own insurance agency, he spent 6 months in training before he was ever allowed to underwrite a policy. A friend of mine who was a premium auditor, he spent 6 to 9 months in training before he was allowed to go out and do the very first premium audit. That type of training is rare in the industry anymore. And for adjusters as well, is simply because, again, time and expense. How much time do I need to train this adjuster to be, or this agent or this underwriter to be proficient? I don't mean professional, I mean proficient, to understand the terms, to understand the concepts. And because it does require money, you've got to hire a staff trainer, or you got to have outside trainers who come in and do it. But there's an expense to that. But the expense to not doing that is what we're seeing right now in the industry. Claims that, more and more claims that are improperly denied, more and more claims that are, I don't know my term that I can do it without offending a lot of people, that are undercut. I'll mention this very quickly. I'm writing a class right now, tentatively titled Investigation, Negotiation, and Rejection. And I have a theory based on what I've been seeing for the last several years. Large claims get investigated, middle-sized claims get negotiated, and small claims get rejected. And some of that comes out of cost. If I figure, as the insurance carrier, and this is an opinion, I don't have statistical data on this, so this
Hey
is an
man,
opinion.
I catch grief all the time. So for me, this is I'm letting you run with this, because they're not going to be throwing their sticks and stones
Yeah,
at me. And
throw it
don't
at
worry
me.
about it. Go for it, Chris. Go ahead and give your opinion on this.
I'm
Why?
gonna give you the rejection. I'm gonna give you the
Tell me why,
rejection.
in your opinion, as an industry insider, I love this. This is going on.
My opinion, again, not supported by statistical data, just opinion, based on what I'm seeing anecdotally. Small claims, basically, I define small claims as what that insured would be unwilling to take the time to fight in court, because it would cost them more to defend it or to fight it than to just suffer the loss and walk on. So that's the size of a small loss, differs by insured. One insured, it might be 20,000. One insured, it might be 100,000, and it would cost them more than 100,000. So I think my opinion, based on what I'm seeing, is the carrier sort of looks at it and says, we can deny this one because they're not going to take it to court. Wholly my opinion, no statistical data. And it seems to, I have heard rumors, and I'm not going to mention the consulting firm. You may know who I'm talking about. Some of the other folks might know who I'm talking about. But there are rumors out there that there is a cost benefit analysis that has been done specific to that, and saying, it's cheaper. We overall, over time, do better as an insurance company if we deny claims than if we pay them if they're below a certain amount. So that's from what I'm seeing, from what I have been told by some other consultants in the industry, especially those on the financial side, that's where we're taking a beating. Also, we're taking a beating because I've already mentioned the training problem with it. Adjusters aren't necessarily being taught the reality of policy language, and they depend on, well, I have been told or I have heard. And when you don't actually apply the policy language, that's when claims go awry. When you don't have the entire policy, that's when claims go awry. When I teach about how to read insurance policy, I also make sure that agents are confirming that all the endorsements that are supposed to be attached are attached, including the correct edition dates, because at the time of the claim, that endorsement is going to change the policy. It's going to say, hey, this is excluded, but we've attached this endorsement, so now it's covered. And if the adjuster doesn't know that, then we got to go through the battle of saying, yeah, wait a minute, you're missing this endorsement, or you didn't read this endorsement, or you don't have a clue what it means. Excuse me for being that cold. That was nasty mean. But that's just the passion that I have in this is it all comes down to the contract. If you don't know what the contract says, you shouldn't be adjusting it or selling it.
So, that kind of leads into a topic I wanted to talk about. You're real famous for writing the 12 rules for reading an insurance policy. And what's the single rule that gets broken the most? And can you share a story, where
Oh,
following it
yeah.
will change the claim? Why don't you talk about that?
The very first rule, and when I teach an errors and omissions class, I always bang on this, because we as an industry stink at this. The very first rule gets broken every time. Confirming the insured's name is correct. The very first question following any claim is the person or entity causing the injury, damage, or suffering the loss an insured? If the answer is no, I don't care what kind of policy you put together. You could have put together the best policy form in the world. If the named insured is wrong, you're done. It doesn't, they don't get to see it. Now, yeah, you might try to get the carrier to reform it and rename the insured, but let's go back to that investigation, negotiation, and denial, rejection thing is they don't have to. They might, but I don't, as an agent, I really don't want to depend on the carrier undertaking to reform the policy to name the proper insured. And I'll give you a property example, and I'll give you a liability example of 2 times where it just got screwed up. Let's start with the liability since we're here to talk about property. I'll come back to that. But I had a situation where an agent called me, and he called me every day for 7 days. He convinced the insured to purchase a pollution liability policy. The insured owned a bunch of apartment buildings in New York City. And so he did a really good job of convincing the building owner to buy a pollution policy. By and by, a kid starts gnawing on the windowsill. Well, guess what kind of paint's on the windowsill? Lead-based paint. So the parents sue the building owner because of the lead-based paint, the pollution exposure. The insurance carrier gets the lawsuit and looks at the policy, looks at the lawsuit, looks at the policy, shakes the insured's hand and walks, or the intended insured's hand, and walked away. Because when the agent wrote the policy, he wrote the policy in the name of the property manager, not the name of the building owner. So the insurance carrier owed nothing because the property manager was not being sued. The building owner was being sued.
Man,
So
we see that. We actually see that quite a bit today with respect to condominiums, property, apartment complexes. They have the property manager do it. The next thing I know, the insured's written the name of the property manager. So it's and then obviously reformation, but that's the reason why I've seen Chip Merlin's desk is because you didn't name the insured correctly to begin with. So why don't you give me an example on the property side?
We had a situation where the policy was written in the name 9 separate commercial properties, 9 separate lesser's risk only buildings, was written in the name of the individual, which is kind of funky. That rarely ever occurs when you have commercial properties. I don't mean lesser's risk only like homes. These were commercial buildings. And it's rare you see individuals owning a commercial building. So I did a little bit of research to find out what exactly was going on. That individual didn't own any of the buildings. They were owned by 9 separate corporations. And if there had been something that had occurred, the carrier would have been within their rights to say, we owe you nothing because the party with insurable interest wasn't our insured. So that's the rule that gets broken. We stink at it. And even if we try to name it correctly as an industry, I'm going to continue to use we don't name them correctly. We don't look at the Secretary of State website and say, is it Inc? Is it incorporated? Is it corporation? What is it? We're not really taking that one step that says, here is who the insured has to be. And the named insured differs based on entity type on the commercial side. So are we getting that correct? I had a claim that was brought up to me yesterday. I was doing a webinar yesterday, and this was brought up as part of the question and answer, that the homeowner, now this I'm not blaming the agent for this. This was actually the homeowner's fault, but it was a negative effect to the homeowner. The homeowner had put the house in a trust and never told the agent. Well, guess what happens when you put it in a trust? Now you have another insurable interest that didn't get addressed, and a loss occurred that resulted in only the husband getting paid for his interest in the house, as opposed to the entire. So they got paid 50% of the value of the house following a loss because it wasn't named properly. So how to read an insurance policy, the very first question is the named insured correct? If it's not, stop, fix it. Then all the other rules that go along with it, there's some that are just as violated, but that one is the most violated of all the rules out there.
I appreciate you raising that. I've been raising it quite a bit in the commercial context, trying to, tell my brothers and sisters that practice in commercial real estate law. It could be even representing affluent individuals, the home office and things like that, because they especially have things in trust. But closely held businesses that also have property underlying you, need to make certain, who it is that owns the property and they're named on there. Is the business where it's operating, what interest do they have? Is there a lease that's in effect between the two of them?
Absolutely.
Does it describe, how the insurance is supposed to be? What kind of insurance in the lease, even if they're close? Does the lease name everybody, properly, have the right value, and all these other things? And a lot of times it's just a failure to follow up on those details. And then people forget that, oh yeah, we're also have an insurance agent, and the person dealing with the insurance agent might not know those rules, and they just don't get, and the agent doesn't check up on it. And the next thing you know, you have a mess on your hands that I think it could have been avoided just by paying attention to that first rule that you're talking about. Who's insured,
Yeah.
That's a great point.
And you brought up something interesting. I have a session that I teach called 7 Simple Underwriting Questions Nobody Asks. And the first 2 are, who owns the vehicle and who owns the building? Because you always have this situation where you have and I know we're not here to talk about auto insurance, but we have a situation where the the business owner buys a vehicle in their personal name, and they call to put it on the business auto policy, and nobody ever asks who actually owns the vehicle, who's it titled to. So that's a whole different situation. And the building question that you just brought up, it's usually owned a small, closely held corporation. It's usually owned by the husband or the wife individually. And they don't address the fact that the person with insurable interest is not covered by the policy. And you mentioned leases and things like that. It's easily fixed. All you got to do is ask the question. It's not a difficult thing to do. And we as an industry get complacent, and we don't ask. We just make assumptions. And assumptions, we all know what that means. I'm not going to say it over the air because that's crude. but that is something that we are not good at. So I'll shut up because I can keep going on about that.
So let me another rule of insurance. 12 rules of reading an insurance policy. Obviously, we can start to read an insurance policy, and an agent, an adjuster, an attorney, and an adjuster, a public adjuster, and a claims adjuster can read the same sentence and come to opposite conclusions. What's the quickest way to reconcile interpretations without ending up in literally a fist fight out at the property or in litigation?
Well, first off, I've never seen that happen. Everybody has always been kumbaya, and has always been the same interpretation. No, obviously, I'm kidding. There's actually a couple of different ways that I've had to deal with that over time, because we all know, and you and I were talking about COVID prior to the conference, or this webinar beginning, the podcast beginning. But when people take a position, whether it be the adjuster, the agent, the insurer, whomever, when people take a position, it's really hard to push them off of that position simply by logic, because it becomes them. It becomes their ownership. A couple of things that I try to do when that is the case, especially when I'm arguing against what I consider to be an improper denial, is context. One of the biggest issues, or one of the major problems I see in a claim denial that often occurs, is that a phrase or a word is taken out of context, and it's used. And I know there's a Latin term for it. I don't remember what it is. You probably do, but they say this was an insurrection because the news called it an insurrection. But what does insurrection actually mean? So they take the whole term out of context. And when you calmly, because again, like you say, fist fight situation, people get very defensive about their position. If you put it to them in context and say, let's look at this in context, that's one way I try to diffuse that situation. The other is also pointing out what you and I talked about earlier, ambiguity. Because if I have a reasonable interpretation and you concede that my interpretation is reasonable, and you have a reasonable interpretation and I can concede, yeah, I can see how you can come to that conclusion, we have competing interests and we have 2 reasonable interpretations. I think the Latin term is contra pro forentum. You can correct me if I'm wrong, that the tie goes to the runner. If it's written by the insurance carrier, which it is, and there's 2 reasonable interpretations, the benefit goes to the insured, not the insurance carrier. So a friend of mine who is one of the smartest people I know and is my mentor in the business. He was in a conversation with a claims adjuster, called him, and they were not debating. They were just talking about the different opinions of how this coverage could apply. And about halfway, 3/4 of the way through the conversation, my buddy, my mentor, said, "You do realize that this creates coverage, right?" And the claims manager said, "What do you mean?" He said, "We have two reasonable opinions, two reasonable interpretations. So now we have a situation that the ambiguity goes in favor of the insured because now you see the ambiguity." So I try to put it in context, and I try to point out the ambiguity. And if they concede, they don't concede on the context, but they concede that this is a reasonable interpretation of the policy, then I've got them in a direction that I want them to go and say this is covered. Now, one of the things that I make sure that I tell agents when I get involved from an expert opinion perspective, I don't take opinions. I don't take sides just because I want to get paid for it. If I don't believe in it, I'm not going to take the side. Like I said, like I mentioned before, I tell agents, yeah, they're right in that. There's nothing I can do to help you on this one. That's a reasonable argument that I can make. So when the carrier's right, the carrier's right. But when they're wrong, and I reasonably believe they're wrong, I'm going to fight it every opportunity I get.
I appreciate that. I think a lot of what you've written shows how things can be interpreted, Chris. Bill Wilson's, When Words Collide book is certainly excellent. And I would recommend to anybody, who's in a position of having to make arguments for coverage to also read that book as well. That goes through a lot of the rules you're talking about, but certainly you've written a bunch of them on there. But hey, let's go to one that I find, because I've spent so much time trying to educate people about what ordinance and law coverage means. You call it the silent coverage killer, and I don't know if everybody fully, I don't think the agents know how to sell. I don't know if you can even figure out how much to sell at all for it. It's a difficult proposition. And, but what's the the errors that professionals make most often regarding ordinance and law coverage, and what can we do to get it fixed?
Well, this sort of the error comes out of lack of knowledge on the agent broker side of the world. And I hate to keep coming back to that, but that's sort of the reality. But there actually is an easy way to sell it, the concept of it. You mentioned coming up with the values. I do have a way to value coverage C, which we'll talk about that in just a second. That's defensible. So when you get to ordinance or law, you have to be defensible in the values you come up with, because you can't be exact. There's no way to be exact because of all the aspects that go into it. But when you're looking at ordinance or law, it goes back to us as an industry improperly explaining the reality of what replacement cost is. Because we tell our insureds, and I've heard this phraseology used, you get new stuff for old junk. Well, that's partially true. Well, a partial truth is a partial lie, because one of the things that the commercial property policy and the homeowners policy says is we're going to put back what was there and only what was damaged. So when you have a loss, we'll stick to the commercial property side. When you have a loss and the building code official comes in and says, you can't use what's still standing, you've taken a partial loss and turned it into a total loss. And if you haven't properly endorsed the policy, the insured is going to be really ticked off because now they're going to have to come out of Hit National Bank to pay for this additional cost when you have told them you're going to get a new building if something bad happens to your building. No, you're not. The commercial property policy is going to put back what was there. But there is an easy way to address this from the agent's perspective. Simple question to the insured, which is, your policy will not pay to put back if the building codes are triggered and you have to start over. Are you okay with that? And I haven't known a building owner yet that said, oh yeah, I'm fine with that. I'll pay for that out of pocket. No, they're like, no, that's not what I want. And you explain to them what ordinance or law is and how it affects the coverage and how it dovetails with the commercial property to not only tear down what's still standing if it gets to that level, but also pays to put the entire building back into compliance with current building code, the damaged and the undamaged part.
Well, that's the rub. How do you figure out in advance all the various building codes that apply, to make it, so that you can do this?
Am I allowed to use a curse word on here?
You wouldn't be the first person.
Okay. And I'm going to try to hide it, but I'm going to say it. To come up with coverage C, it's a swag, or at best
Okay.
a Wagner. Now, we all know what swag is, a scientific wild ass guess. A Wagner is a wild ass guess, not easily refuted. So when you're trying to come up, coverage A is easy because that's the difference between the amount of damage and the amount of coverage you have on that building. That's easy. B is the removal of the debris of the undamaged part of the building. That is a pure guess because we're not really sure, because it differs based on state. In my state, it differs based on county, how much building can still be standing before the building code official, the person with the clipboard, says you got to tear down and start over. So you're guessing at that. Coverage C is a guess of irreducible complexity. It goes into, you sort of have to take into account, which is why I developed an Excel spreadsheet to make it defensible. You're the attorney. I want to go to you and say, hey, Chip, this is how I came up with that value. It's defensible. It's explainable. It's based on the age of the building. It's based on, condition. Have they been upgrading the building? Is it like it was? All these different factors that you have to play into it to guess at a coverage C. The good thing about coverage C is there's no co-insurance. There's no penalty to it. The bad part is if you underguess, it's coming out of their hip. It's coming out of their bank accounts, and they're not going to be happy, and they're going to sue the agent because of it. So disappointment's a function of expectation. We told our clients you're getting a new building for an old building. No, you're not. You got all kinds of factors that go into that, and we have to address that on the agency side as to how we address that. Ordinance or law, this is just my opinion based on 35 years in this business, is the second most improperly or undersold property coverage out there. The top three: business income, ordinance or law, and leasehold interest. And you and I hadn't even talked about leasehold interest ever, I don't think. So,
There's a whole, yeah, there's a book that I think Malecki wrote about it. I don't know if you have a book on it, but it
I
is
don't have a book, but I do have a treatise on it.
it is the leasehold, ensuring the leasehold interest is a
Yeah.
study in itself that I think it's a very complex for claims adjusters to go through and fully understand. It is very, so while we're talking about it, what's the most misunderstood issue with respect to leasehold interest coverage, and what should we be doing about it?
But the greatest misunderstanding about it is that it exists. When I teach, and I'm sort of being tongue in cheek, but I'm sort of serious. When I teach an E&O class, especially when I teach property, I always give those top three: business income, ordinance law, and leasehold interest. And I say, I'm gonna stop here and say, how many of you have ever heard of leasehold interest? And on average, 2 to 3% of agents will raise their hand. Then I ask the follow-up question: how many of you have written a leasehold interest policy? And I think I've had 5 in my career, agents who have actually written it. And I warned them about it because in the next 5 to 10 years, that's going to become one of the most important property coverages out there. And understanding the fact that if your insured has a favorable lease and they lose that favorable lease because of a major loss and they have to go back in at the new market value, that they could the example I give has a $900,000 additional expense over 5 years they wouldn't have had because of the loss of a favorable lease. And the reason I say it's going to be the most important coverage in the next 5 to 10 years is because of COVID. Our lives are now divided by pre-COVID and post-COVID. Well, during COVID, everybody went home. Everybody went to work
Right.
from home. So a lot of businesses discovered that they didn't need real estate. So they moved out of the buildings. Well, landlords who own these buildings want people in the buildings. So in order to get people back in, they have been giving favorable lease rates. Well, now as the trend is now to get everybody back into the office, when the vacancy rates start going back to where they were pre-COVID, most leases, as you are aware, have in there, if we suffer a major loss, we get to cancel this lease and have to start another one when the building is rebuilt. They're not going to go back to the lease rate you had. So if you had a 15-year lease and you got 8 years left on it, the insurer is going to be really stuck with a much higher lease if they want to go back in that same building, that same location, because that is now the market. They don't go anyplace else and get a better rate. It's everybody's got that. So agents, and I know we're not necessarily talking to agents right now, but agents need to know this right now because of what's going to be coming in the next few years as the businesses start going back into their real estate that they have moved out of 5 years previous now. So that's the biggest thing of leasehold interest, is knowing it exists, knowing how it works, and discussing it with your insured. And when I was teaching this one in one of my classes, one of the agents raised his hand. He said, "And I got in this business. Why?" I said, "Because you enjoyed the thrill of learning things like this, because it is a financial discussion with your insured, saying, hey, you're paying $15 a square foot. That's a favorable lease because right now the market's $30 a square foot. If something bad happens, you're going to come back in at $30 a square foot, and you're going to double your expense for your real estate overnight,
Well, for
relatively
what
speaking."
it's worth, Chris, on the claims side, when I'm dealing with public adjusters or the company adjusters on the other side, we're dealing with, I might be representing the tenant or representing the landlord, I quickly find out how sophisticated they are, dependent upon how quickly they ask to read the lease and then understand how the coverage works, with respect to the lease. And
Yeah.
those who don't look at it at all, I know they don't know what in the world they're doing on it. They're not that complex yet. And for all my public adjuster friends, as you get to you're doing the next level of commercial, if you're doing any commercial at all, you better know how to adjust the leasehold, coverage aspects of a claim. It's quite a bit more complicated, and it's a study in and of itself. So
Yeah.
I know we hadn't talked about it before getting in for tonight, but you're absolutely, right on that. And I appreciate you raising that. I'm going to give you a little leeway on the next one. And I know you and I could probably talk for 3 hours as insurance nerds and stuff, but one of the things that, with respect to insurance coverage interpretation, that drives me nuts at times is the anti-concurrent causation clauses that come out. They vary a little bit in how they're written, but I can still remember after Katrina, Nationwide Insurance Company making the argument, if there's just an inch, 2 inches of flood damage whatsoever, we don't pay for any of the rest of the claim, and that's how we read this policy. And the Mississippi Supreme Court judges were rolling over while they were making this argument, thinking how crazy that could be. But I honestly could see how they could read that their coverage anti-concurrent cause literally and come to making that argument, in front of the justices. What do you see on this? I'm going to give you some leeway, and what are we doing as an industry? Because it seems to at times mean whatever the heck, somebody wants to make it mean at the time.
I think the danger in the anti-concurrent causation language is when you go from the ISO language to a proprietary form, because the ISO language is pretty well adjudicated. It has such loss. I mean, such loss means what we're excluding is not covered, which if you read it in context means the water damage isn't covered, but the wind damage is, so to speak. So we're not going to cover ordinance or law. Well, I mean, if they want to interpret it that broadly, they're going to say, well, if we have a building code issue, which I did get involved in a claim that they did try to make that argument, and I quickly killed that one off. I said, yeah, that's not how this works. Let's go back to concurrent causation wording and anti-concurrent causation. It only applies to ordinance or law. It doesn't trigger the exclusion for property damage. They really tried that. So it's not weird that that this is a reasonable question. But when you go to a proprietary form and they remove a phrase like such loss, it does, like you say, it opens it up to interpretations that are unreasonable in regards to the intent of the language. The intent of the language obviously is we're not going to pay for the water damage, that's why you buy flood coverage. But the wind damage we're going to pay for, or we're not going to pay for the ordinance or law unless you endorse the policy. That's why you buy an ordinance or law endorsement. So, I mean, it's a matter of what language is being used. ISOs is pretty, to me, again, it's sort of like, reading the King James Version. If you grew up on the King James Version, you know how to interpret the King James Version. I grew up on the ISO.
I didn't know we were going to get into religion tonight talking about insurance, but if you're into this enough, it's the
same. It's the same. It's the same thing.
Right. So the King James Version of insurance. All right.
Yeah, the ISO policy language. I know what it means because that's what I grew up on. But when you start stepping outside of that, and obviously with my role at ISO, I dealt with a lot of product managers for insurance carriers that had proprietary language. They could do whatever they wanted to, and I wasn't arguing with them over what they did. But when you start putting proprietary language and taking away adjudicated language, problems get created.
Yeah.
My interpretation, my belief of how that language works. So when we have that situation where it can be looked at and held that broad, that to me is what creates the problem. Because ISOs, we actually had a Department of Insurance when I was at ISO that had a problem with our anti-concurrent causation language, which we have been filing, and ISO has been filing for at least 35 years and probably for 50 years. The same language has existed in the policy. So how they all of a sudden said we don't like this, they were interpreting it too broadly as to how the policy. So even a Department of Insurance, I don't remember which state, which I intentionally forgot, even the Department of Insurance said we think this creates too broad of an exclusion. To which I had to respond and say, let me explain to you how this works. And I think they bought it, but it's kind of interesting that after that long that they would all of a sudden have a problem with the same language.
Let me just, we didn't talk about this, and so I'm just kind of curious. It's been my observation that some of the major personal lines carriers, especially
Okay.
whether it be homeowners, and in commercial, but it's primarily in homeowners, they are changing the ISO language ever so slightly and making the words, I almost think, a matter of a race to the bottom, saying, well, we're trying to make this more clear, but really what they're doing is providing less coverage to policyholders without really advertising the significance of what they're doing in order to compete on rates, premiums, or whatever. And I know I'm skeptical. I represent policy, but I'm just curious as a professional, do you see that? Am I off base or
No,
what?
I think you're right. Well, I'm gonna go back to the auto side. The personal auto policy in Florida allows an exclusion that is not excluded in the ISO policy form, specifically for food delivery. I'm not talking about Uber and Lyft and DoorDash and all that stuff. I'm just talking about food delivery. There's specific exclusionary wording in Florida that's allowed in Florida that doesn't exist in the ISO language. So when we start going statewide basis and we start going proprietary basis, there are slight wording changes that create less coverage, whether it's for premium, whether it's they just, forgive me for saying this, where they just don't realize the interpretation, because a lot of times the product form, the product managers and the underwriters don't know what the adjusters are doing in interpreting coverage and how they're interpreting the policy language, unless it makes it up the ladder. So they may not have intended for it to be interpreted this way, but it gets interpreted in X way, even if that wasn't the intent, because what's the adjuster got to go on, what's sitting in front of them, and how they interpret that. So that it requires somebody like you and somebody like me to come in and say, that might be your interpretation of it, but let's talk about how this actually appears to read. Because now we're back to the contextual, the ambiguity, and everything else that creates the problem.
I'll push it one more step. We didn't
Okay.
talk about it. I didn't write this down as any possible thing, but there's been a few of us that have been, and so you have a lot of leeway on this, Chris, but a lot of us been saying, should we have a minimum all risk insurance policy to prevent some of this from going down? It's almost the same way that we had to set up a standard fire insurance policy from insurance companies scrivening out of coverage, 140 years ago when they started up, to doing the same thing now with all risk policies.
Well, see, you're in luck, because I live in North Carolina, and in North Carolina, on the homeowner side and the personal auto side, we have the North Carolina Rate Bureau, which requires a certain minimum policy language, just like standard fire policy, but it is an open peril policy language that says all HO3s have to meet this minimum standard. Now, the carrier can do certain things, it can file certain things and try to get around it, but there's still a certain minimum standard. So I am not against a minimum standard that says this is what, because we know our insureds do not read the policy, even though a lot of state laws say it's on them to read the policy. They don't.
No, and they wouldn't. We just talked about having to go to classes for months to understand policies and the nuances of it. I mean, I laugh when Texas has a rule of law where policyholders have to read their policy and they are expected to understand it. Give me a break. But anyway,
Yeah, and the
I
adjusters
didn't
don't
I
even.
didn't know that. I
But
didn't know that. I appreciate you bringing that with respect to North Carolina law.
yeah,
And you think that might be good for a majority of the states, I imagine, to do something like that.
my personal opinion is yes, because it's a consumer protection. Because at least I, as a consumer who doesn't know insurance, who doesn't want to take time to read my policy, is not going to take time to read my policy until I retire and have nothing better to do. Which is why I never liked writing retirees, because they actually sat down and read the policy and would call me and ask me questions. But most insurers don't take that time to do that. So it's a consumer protection aspect of a minimum standard language, which is, again, carriers are free to do whatever they want to. They can use ISO language or not use ISO language. They can use part of it in proprietary otherwise. But I, as the insured, who doesn't know anything but what I'm being told on the TV that saved me 15%, how do I know that there's a difference between company A and company B and what their policy language says? I don't. And unless I have a loss and find out, you mean I could have had coverage for that if I had stayed with company A, but I moved to company B, so now I don't have coverage for that? That's when they find out. And
Yeah.
that's why I'm not against a standard, a level standard that says everybody is going to get this. Now, if company A, company B, and company C want to have different additions on top of that, in addition to that, fine. But everybody has to have this.
There's a number of people I know in my audience that are going to be public adjusters, and they're working on a number of complex claims. And sometimes, claims going on, and then some of the construction starts, oops, and they find something during this construction that it might be a year later.
Yeah.
And I don't know if this might be pressing you a little bit, but what's your experience about what would be the evidence that would most impress a carrier to, review and reopen up aspects of a claim when that happens?
Are we talking about the valuation perspective of additional cost? Or are we talking about we found that there was damage that's covered that wasn't covered, or both, or
How about both?
oh,
Because they
okay.
both happen quite a bit.
Are we near time yet so I can call an end to this and not answer that question? No, I'm kidding. Um, the, the that is really a good and tough question. If it's a coverage issue, obviously it's a matter of you've got to show them policy language, show it in. I'm a big believer in context. I know when I read claim denial letters, the adjusters put all the context out there, but even in those cases, they leave out context. I don't think it's intentional necessarily, but they do leave out some context that is pertinent to the claim situation. So giving it back to the adjuster, giving it back to the underwriter in context of, hey, we didn't know about this damage. Some of it is we just didn't know about it. So that is a matter of just saying, this is new to us. This wasn't.
What about the valuation? The contractor.
That's the hard one, because that's, again, we were talking about investigation, negotiation, and rejections. A lot of that on the property side has to do with the value of the property. So that, as much as we would like to keep that out of court, that might have to end up in the appraisal process first before it goes to court, because now we know something. It's just like whenever there's an auto accident, there's always damage that nobody sees when they do the estimate. So on the auto side, they know it's coming. On the homeowner side or the commercial property side, they may not have realized that this wall was warped, or the building code official comes in and says you can't use that anymore, which is an ordinance of law situation. Which may be tied back to the actual initial loss. So it's I don't have an easy answer. I wish I did, because if I did, you would never see me again, because I'd be down actually living closer to you.
Well, here we don't have a lot of time left, but I was intrigued early on when you mentioned trying to get within 24 hours. Was it 8 different topics that you were going to teach somebody about within insurance or something? What exactly was that you're coming up with?
The 7. Oh no, the basics and beyond.
Yeah, the basics and beyond.
Yeah, it's
24 hours.
Yeah. It goes through the concepts of insurance, the concepts of things like insurable interest, what constitutes negligent conduct, legal liability. I mean, all of those basic terms that you learn and hear in insurance, and don't really get a hold of them until you're about 6 years in. So I try to take that and let them skip over the 4 years of accidental learning.
So if we made up a rule that said insurance professionals in America had to take an hour of a class every 3 months, everybody keep their license, I wish I could make it. If you practice insurance law, you got to do this as well too. What would the next 4 sessions cover each quarter that you think would be the most important for us to do, Chris?
Well, we talked about one earlier, insured status, that you got to get right. You got to understand that from the liability side, you've got to understand contracts and contractual risk transfer if you're doing contractors and things like that. So that's a class I would definitely require everybody to have. Although we're not here to talk about auto, understanding business auto coverage symbols. Symbols are far more complex than anybody thinks they are. Business auto is actually more complex than anybody thinks it is. So named insured status, which covers property, liability, the whole gamut of it all, getting workers' comp and all that, getting that right. And speaking of workers' comp, the fourth one would be extraterritoriality and reciprocity. What happens when a worker crosses state lines to work on a temporary basis? Those would be the 4 topics I would definitely require, because those are areas where I wish you'd given me 5 or 8, because now we get into umbrellas versus excess policies.
So let's do this then. What would be the next 4 if the practitioner was just doing property insurance?
Still named insured. The basics, and I mean basics at a very high level, of business income. I could combine ordinance or law and leasehold interest into one class. Wouldn't get the depth because of the reality of those 2 requires an hour and a half, 2 hours each minimum to get the reality of those. But business income, understanding the reality of the period of restoration. That is one area that we underestimate routinely. And I've taken business income classes where the teacher didn't understand it. And I was looking around the classroom with people who were in there, and I thought, do I really need to correct them in front of these people? And I looked around who was in there. I said, no, I'm not going to do that to the teacher because I don't want it done to me, but they were just wrong. Understanding period of restoration is the basis of everything in business income. If you understand the reality of a worst case period of restoration, everything else is easy. If you want to do 2 hours on business income, then I'll go into how to finish and complete the business income report and worksheet so that you can estimate the best number for the coverage and things like that. Let's see, what else could I? Again, understanding who owns the building is huge. What else do I like teaching as it relates to property? COPE. I think COPE in general is not taught as well anymore as it should be.
Why don't you explain the concept real quick to everybody, and then we'll move on to this will be the last question I ask before Kathy. I'll open it up for a few minutes for you to tell me what questions are out there.
Okay, so COPE, construction, occupancy, protection, and exposure. That is the basis of commercial property underwriting. It's been the same basis for 400 years. They've been using it since 1699 or something like that. COPE. What is the building constructed of? How old is the building? What is the square footage of the building? Occupancy. We have 2 parts of occupancy and property: what they do and how they do it. A body shop is a body shop is a body shop, but not all body shops do the same things the same way. They store their flammable and combustible liquids differently than everybody else. So understanding occupancy, protection. Fire extinguishers are wonderful, but are they appropriate? Sprinkler systems, wonderful. Are they appropriate? Do they work? I got a good story there. We don't have time to talk about it. Protection, construction, occupancy, protection, and exposure. What are they close to? Not only from another building, but what are they dealing with from a geographic situation? Are we looking at wildfires? Are we looking at hurricanes? Are we looking at tornadoes? Are we looking at earthquakes? Are we looking at, forgive me for bringing up Florida, but are we having holes opening up in the earth where things fall into? So things like that. So that's the basics, the real quick part of COPE. And that is something that I love to teach because most agents and most adjusters have never heard it.
I think policyholders, and I think policyholders, if they thought about it, could think about those various things with respect to their own risk management and what they might be able to do to be a more attractive risk to
absolutely. Because one of the parts I talk about in COPE is the fact that the insureds screw themselves. And if they understood how they're screwing themselves, they wouldn't do it.
So Kathy McConnell, you're back there. Thanks for coming back out to save me. Or do we have any good questions for Chris?
We have a few questions, and we've had quite the chatter going on. So I think everyone's introducing themselves. And so I'm really impressed with the group we've got tonight. And they're having a lot of fun with each other because not everybody's just a public adjuster. They're realizing, there's a group of risk managers, insurance consultants, agents. Nat like to point this out, but we all have one thing in mind, and that's the policyholder. So kudos to everybody listening. And so a couple of questions from Annabelle. If multiple small incidents occur over time, in quotes, minor leaks or storm related damage, does the policy consider them separate claims or one cumulative loss, and how can that affect deductibles?
Well, there's too much fact based in that for me to really answer that question. I mean, is one an ensuing of the other? Is it truly two separate events? What's the proximity of dates? So I don't really have a good answer to that. If it is considered one event, you got one deductible. If it's considered two events, you got two deductibles. So I don't have a good answer because of the fact based nature of that, because every situation is a bit different. Chip, you want to chime in there?
I can appreciate the question because it's coming up all the time in residential water losses where some companies and their policies seem to be hell-bent on not paying for any, not even, and we didn't even get into ensuing loss. I know we talked about it possibly, but I mean, they're just not going to pay for any damage, whether it's direct or ensuing damage from any type of water leak. And typically, if people see the water leak and they're there, they stop it right away. The problem is when it's under the slab or it's behind a wall, you don't see it for months sometimes. And exactly, who knows? All I know is when they discovered it, holy cow, we got a huge problem. And there's been a lot of issues, at least on the claim side, from what I see out there. And there's just a real battle going on. And some of the companies seem, without advertising it, what they ought to say is, we don't cover your residential water damage. Then we would understand and everybody would go somewhere else, but they don't want that. They just, they want to take the premium and hope it doesn't happen. What's the other question, Kathy?
So Annabelle's second question is, are there any endorsements or optional coverages that most homeowners miss, which could significantly increase coverage for water intrusion, mold, or hidden damage?
Yeah, there are two available endorsements for the water damage. Depending on what state you're in, which one they're using right now. But there is an endorsement for the water damage. The mold and hidden damage, that's a different conversation. Chip might have a better insight on that than actually I do. So
I would say, what we're conducting right now when I give speeches, you'll love this, Chris. I'm asking everybody in my audience, who pays the fairest of all the insurance companies? And then we also ask who pays the worst. Now I'm going to go out and publish these, but I actually believe that I can honestly say that Chubb is coming out there, way up. Pure is coming out there. Amica's coming out there. Surprisingly, to me, it was surprising. USAA was coming out there. And I think those companies tend to look for coverage and ways to pay and take care of their policyholder. I won't get into the worst right now. I'm going to try to keep this on a optimistic side. I would suggest people consider buying the replacement cost endorsement so you get paid for that right away rather than waiting, especially on the contents. That can help out, quite a bit because there tends to be, when you were talking about the small denials, I find that, I call that term breakage. and one of the breakages when they pay the ACV, people hate to turn in paperwork afterwards, and they're just not getting their replacement cost coverage. And you can buy a special endorsement for that as well to increase your coverage. But yeah, I would, Chris, that's a great point. And actually, Annabelle, thank you for asking that. In today's day and age, the way those water claims are going with most major personal line carriers, there is a battle going on.
Yeah.
And I would look for that endorsement and ask for that. And the agent should be trying to sell it.
And it doesn't cost that much from what I remember. So it shouldn't be a hard sell.
I mean, there was this one, a Liberty Mutual agent sold a client of mine on the contents replacement cost, and it was less than $100. And it was nearly $100,000, type of extra payment right away. I mean, he could have waited, the guy, but it stopped from him out having to collect and go back and do all this stuff and wait. You know, you get up to some states, some policies 180 days, some it's 2 years to do your replacement, and you send in all the receipts. What a pain in the neck.
Well, I do want to. I do want to make a comment to the adjusters listening, and I'm not trying to be mean by any stretch of the imagination, but one of the things that I've seen with clients is they've never been through this, and the adjusters go through it every day. So just remembering where the client is in this is new. They don't have a clue what the process is. So it's very easy to get frustrated. Even agents get frustrated with it, with the questions and everything that clients might ask. But we have to remember this is new. This is personal for them. So just chiding you just a little bit.
Well, Kathy, I think if you're, we all heard the dog in the background. Are there any more questions out there by any chance? If not, it's a little bit after 7. And while Chris, I could speak with you for 3 hours, and I would love for people to really learn more, you know, from you. Kathy, are there any more questions out there?
I have quite the dogs barking. My apologies to everyone. And I don't know if you can hear my question. I love this question because it has to do with today's blog post. And so
Okay.
I wasn't sure if Chris was able to read it, but it was about extra expense and regarding grammar, disallowing full payment of extra expense that's incurred. This is from Bruce Smith, and he's in forensics.
Chip, I'm gonna let you, because I honestly didn't get a chance to read your blog
so
today.
It was interesting. I think people probably thought I wrote about it because I wrote a article 17 years ago, which quoted you about the importance of buying business income coverage and getting it right, and everybody having it. And you've written so many articles, and this is 17 years ago.
Yeah.
But the truth that there was a case that I was researching some issues with respect to bad faith in Mississippi, and I came across this matter that was just decided at summary judgment on a State Farm insurance policy. And it had to do with the extra expense coverage. And like on the very last coverage for temporary stuff, and there's a limitation on it in the ISO.
Yeah.
Well, State Farm made an indentation, so it also applied to all the coverages above. So the only way the extra expense is going to get paid is if it actually lowers the amount of the business interruption, the lost income claim, which often it far exceeds that. And, you know, so it's a major factor with respect to reducing coverage. And I mean, the only way I can tell everybody about that, and I could have been a lot harder, but if State Farm executives are listening to me, if you're a State Farm agent, if you're an agent who doesn't sell State Farm policy, you could use this as a classic example that the wording in insurance policies mean a lot. And those insurance scriveners, by changing it, and State Farm in that case, I didn't write it in there. They literally went to their operations guide that said, no, we intended it to mean it that way and to reduce the coverage. And the only way I think that actually happens is if we're trying to take advantage of this situation and say our product, we sell the same thing for less. Yeah, but it's not the same product. It is a different product. Now Chip Merlin's really getting on. I mean, this really pisses me off because I don't think the agents know. I think somebody, an executive at State Farm in the underwriting department, knows to get an advantage over one of their competitors. They're going to change the language ever so slightly and just where they place it so that it applies to restrict the coverage. And I was really upset about it. And I wrote, if you get a chance to read my blog post about it, it really came through. And Bruce, thanks for raising it. I know you do business income calculations. You're a forensic CPA, and that's what you do for a living. So, but you know, it would be only Chris. It would only be one of us, one of these insurance nerd people who do this for a living. They might catch on to that, you know, up front. And I just, you can see how I feel about it.
Yeah.
It got me here at the end, but
you were kind of blasé about it. You really weren't too much into it.
Oh, I just come on. And it's State Farm's been a great company, was a leader in the field, but what are you doing out there, guys? You don't need to do this. You need to tell everybody else we don't do this, and neither should you. Instead, if the leader in the industry is doing this, you're just telling all the rest of the personal lines carriers, this is okay. It's open season on your customers. we're going to make these small little changes that only insurance coverers like Chris and Chip are going to find. That's not right. So, Kathy, are there any more questions? I know I don't
I think on that note, and maybe we gotta. If someone's saying, take a breath, Chip.
Take a breath.
Take a deep
All right,
breath.
guys, I appreciate Chris. Thank you so much.
Oh,
You've
thank you
been
for having
a
me.
Wonderful, I would say resource, but an individual to know and somebody I've learned so much from in depth. And for everybody who's watching, I encourage you to. And matter of fact, I think Kathy, you put somewhere in the chat section, and I'll make certain I'll put it up in a follow blog where people can go to see all the books that you've written. And I would encourage people to learn from you in the future. I called you the relentless teacher, so I hope you keep being relentless because you have a lot to say, and education is where this industry starts. So thank you very much for all you've done. And thank you very much for being our guest, and everybody for watching. Thank you very much for participating.
I appreciate you having me.